Hello, this is Kelly Longtin from Kelly Longtin Law, and today I wanted to talk to you about probate. Now, after a loved one dies, their money and property must be distributed to the right people, either according to their will or the state's default distribution scheme, called the laws of intestate. While most people want the settlement process to be done as soon as possible, probate can take between 18 and 24 months. Yep, you heard that right. It's an awfully long time for probate. The time delays create unnecessary stress, especially for families who need access to these accounts or property immediately. There are many reasons why the probate process takes so long. Let's talk about 5 of the most common. The first is the amount of paperwork. Managing probate-required paperwork can be a monumental undertaking with structured timelines and court-imposed deadlines. Second is the complexity of the estate. Some estates have numerous or complicated accounts and property, and they just simply take longer to probate because there's more items that need to be accounted for and valued. Next is the probate court caseload. Most probate courts are dealing with high caseloads and limited staff. And then there's challenges to the will. Heirs, beneficiaries, and those who thought they'd be beneficiaries can object to and challenge the will's instructions and legal requirements. While state law dictates the length of time period during which they must object, will challenges can add years to the probate process. Some of the most common challenges include assertions that the will maker was incapacitated and didn't have the ability to make a valid will. Maybe they were delusional. They were under some undue influence. Somebody was pressuring them to do something. Or maybe they were a victim of fraud. The next reason why probate takes so long is creditor notification. The deceased person's creditors must be notified of the deceased person's passing and the probating of their estate so they have time to submit any legal claims for debts. This time period also varies from state to state, but it is generally 4 to 9 months. The bottom line is that while most state probate laws are designed to keep the process moving along in a timely manner, that's more of a plan than it is of a reality. Simply put, had the deceased person created a trust to hold their accounts and property, the long, complicated probate process could have been avoided. By creating and funding a trust, those accounts and property are no longer viewed as being owned by the deceased person and are not subject to the supervision of the court. Their distribution is controlled by the instructions left in the trust agreement. Administering a trust instead of a probate is usually quicker, meaning that beneficiaries receive assets more quickly, costs are drastically reduced, and stress levels are kept to a minimum. First, if you need help settling a probate estate, we can help you move the process along and remove some of the burden so you can move on with your life. Second, we can help you make sure you never burden your loved ones the way that you've been burdened. How, do you ask? We'll show you how to avoid probate with a trust. Give us a call today, and we can help you go through the probate process, deal with any trust administration, or make sure your family doesn't have to endure the same situation. And as an added convenience to our clients, we're able to meet with you either in person or through video conferencing. I look forward to speaking with you, and thank you for joining me. I'm Kelly Longtin from Kelly Longtin Law.